right. We are now back to week number 4. Thank God Almighty. We've made it through 3 weeks and you're still here. All right, so we're going to be talking about agency law. And let me just highlight a few things here that are critical for businesses. Number one is the ability to distinguish between employees and independent contractors. Very critical. Why? Because an employee carries all kinds of liability for torts, for contracts, if they're acting as your agent within the scope of your their authority in their job. And independent contractor, they're independent. They're on their own, and so if they have any problems, their problem. So businesses naturally like independent contractors because of the liability, the cost, the taxes, the panoply of responsibilities. But remember, at the base here is this area of agency law. In agency law, the way you have to look at this is there's a principal and an agent. The agency relationship can be contractual, it can be implied, it can be expressed. Doesn't need to be in writing. It can be gratuitous. Somebody can just agree to do something for you, and they're your agent. And if they screw up, you're going to be liable for that. There are certain levels of duty you have between the parties and certain rights, but your book sets all that out. Well, you know, when you hire somebody, they're a worker. So the question is that worker a employer, independent contractor? And this goes to the issue of you have here the concept of right there of respondeat superior. This is let the superior respond. This is the term used in employment law. So make sure you understand that concept. How can an agency relationship be terminated by contract, express, or applied, death, all that stuff? So keep that in mind. Great resources here for you, various videos on the types of agency relationship, how they're created, liabilities, especially pay attention to these videos on the principal's liability for an agent in tort and contract. And this is referred to as vicarious liability. So if you have an agent that screws up, or signs a contract, whatever, and they're acting within the scope of their authority, you're going to be liable for that. I do include a number of very useful things on the use of agents in estate planning, like durable power of attorneys, living wills, things like that. This is all free information you should have. If you're in the military, you're probably familiar with these types of estate planning tools, but everybody should have one of these. All right, real quick about employment law. Again, the assumption here is that you have an employment relationship. This is not an independent contractor. Again, make sure you understand the difference. Independent contractor, truly independent. The more control, as you'll see in some of the resources, the IRS and the state of Washington says the more control you exercise over an employee, the more they're going to be a worker, I should say. The more control you exercise over a worker, the more that worker is going to be deemed an employee, and you're going to be responsible for taxes, liability, for torts, contracts, etc. For the most part, people are employed, at least in the state of Washington and most other states, I think, except Montana, on an at-will basis, meaning you can be terminated for good cause or a bad cause, just so long as it doesn't violate a contract, a statute, or matter of public policy. And if you have an employment relationship, then the anti-discrimination laws kick in. The two basic categories of these laws are those that are direct discrimination and indirect discrimination. Direct, like someone doesn't hire you because of your age, race, sex, disability. Indirect is where there's a policy that has the impact, the disparate impact of discrimination. So again, the two basic, that's one of the two basic types, disparate treatment and disparate impact. And your book talks about several federal anti-discrimination laws. The biggie is Title VII. Remember, states add to this, add protection. For example, the state of Washington protects discrimination based on sexual orientation. Federal law doesn't explicitly do that. I want to highlight harassment simply because this is a big issue with businesses, especially sexual harassment, which can cost businesses a huge amount of money. And again, under the concept of respondeat superior, which you just talked about with agency law, if you have a supervisor engaged in some behavior that is, amounts to either direct sexual harassment, quid pro quo, or indirect, where they have a hostile environment, you're going to be liable for that. Liability also flows from if you compel a worker an employee to deal with a customer that's engaged in that, you can be liable for that. Very important that you have training, things like that. Your book talks about that. Let me just say, harassment can be based on sex, race, age, any other disability. So don't just think of it as sexual harassment, but it is discrimination, and it is illegal. Lots of videos on this. Take a look, especially on this concept of vicarious liability and the use of agents in estate planning. That's the end of week 4.